Okay, perfect. We're recording. So welcome to our workshop. It's May 15th, and we're going to be talking about how to stay in compliance with the CSFRA and the MHRSO. As you know, we have probably more rent stabilized apartment buildings than we do mobile home parks. So this is a little bit more geared toward the CSFRA than the MHRSO, but they sort of all kind of apply. All right, but before I get started, I want to have a little reminder that city staff is not able to offer any sort of legal advice, but we do offer facts and best practices and overviews of the local rent stabilization laws and other state laws that might interact with those. All right, so both the CSFRA and the MHRSO are meant to stabilize communities by reducing housing turnover in certain types of rental units or mobile homes. And it does that in three main ways. First, stabilizing rent. So it has sort of those rent limits, and we'll talk more about that as well. It also provides eviction protections. And then for our property owners and our mobile home park owners, ensuring a fair rate of return on your property through a petition process. And the CSFRA was passed by voters, while the MHRSO is an ordinance that went in place through our city council. So a little bit more background. Again, most apartment buildings in Mountain View were built before the law went into effect, which was December 23rd, 2016. And therefore they are covered by the CSFRA, which stands for Community Stabilization and Fair Rent Act, but it's very long-winded, so we call it the CSFRA for short. We have fully covered and partially covered properties here in Mountain View. The majority are fully covered, and that's where both rent stabilization and eviction protections apply. And those are for properties that have 3 or more rental units on them that were built before 1995. And then our partially covered ones were built between 1995 and 2017, and that's because of a state law. So you'll see here kind of the same thing, just breaks it out in a chart. And then over on the right, you'll see we do have some exemptions for our CSFRA. So if you have just a single family home on its own lot, its own parcel of land, that's exempt. Condos, companion units, duplexes, hotels, and other 100% government subsidized rental units are all exempt from the CSFRA. And that kind of comes into play a little bit more when we're talking about our registration requirement. And you can apply for exemptions on your property there if you have them, and it reduces your annual rental housing fee. So again, mobile homes are also covered by their own ordinance, and it covers mobile home owners that own the actual home and rent the space. So it covers that renting of the space. And they rent that from the mobile home park owner. And then it also covers mobile home renters who are actually renting the home from the mobile home owner or the mobile home landlord. So it covers the renting of either the space or the home. And so this is sort of what we are here to talk about today, substantial compliance with these local rent stabilization laws. And so we have regulations both for the CSFRA and the MHRSO. They are both Chapter 12 for compliance and general remedies. And it spells out exactly what a property owner needs to do to be considered in substantial compliance with the respective law, either the CSFRA or the MHRSO. And sort of the big thing that would happen to a landlord if they are not in compliance is that they are not legally allowed to raise rent on their tenants if they're out of compliance. And they're not able to file one of those petitions for an increase of rent on the property. So no kind of rent increase at all if a property is out of compliance with the law. And we'll talk about exactly what that means. So here are the 5 substantial compliance. So there's other little things you can be out of, not that you should be, but you might be out of compliance with. Like maybe you didn't upload a notice that you were supposed to, or something like that, which wouldn't be considered substantially out of compliance and therefore wouldn't necessarily affect your ability to increase rent. So it's not like every little thing, but it's just these big substantial components of the laws that you have to be in compliance with. So there's 5 of them. So landlords must have had to roll back their rent for any tenant that was there October 19th, 2015 or before. They have to have increased the rents in accordance with the CSFRA. And if they ever unintentionally maybe overcharged rent, they would have had to correct that and refund that rent so that the tenant's at a lawful rental rate. The landlord must have had paid all their annual rental housing fees. They have to have registered the property, and they have to maintain substantial compliance with the local state health and safety laws. So the property basically needs to be habitable. And so we're going to go over each one of these. So if a property is not in compliance, again, like I said, the property owner is not able to increase any rent. The city will send a letter to the landlord letting them know they're not in compliance. And if the landlord maintains non-compliance, then a follow-up letter goes out to the landlord with a copy to the tenants, letting them know that the property is out of compliance. And then there are certain late fees for non-registration and failure to pay the annual fee. So sort of compliance in a nutshell. And now we'll go over each of those 5 key compliance measures that I just talked about. So the first one is sort of all wrapped in around rent and charging proper rent. And so under the CSFRA, what is included in rent? So we have that base rent amount is sort of the initial amount when the tenant moved in. And that is also going to include all other types of fees that the tenant pays as part of their rent. So that would parking fees, pet fees, storage, any other housing services, if you have a gym or something like that, that would all be considered rent. And then that can be increased every year by the annual general adjustment or the AGA, or if there's a petition to lawfully increase the rent, or there's ways for landlords to bank rent increases and give them that way. So those are all sort of legal, allowable ways to increase rent. And then deposit is not included in the definition of rent under the CSFRA. So the deposit would be, the security deposit, could be a pet deposit, and that cannot be increased during the tenancy. So once it's set, it kind of stays where it is. So it's not included as part of rent. It is its own separate deposit. And then something that I'll touch on a little bit here, but I'm not going to get into it too much, but I do want to mention it. There are separate entire workshops for utilities. In case you're interested in that, I can let you know when the next one is. But there are new regulations for utilities of fully covered CSFRA units, and that is for any new tenancy that started after March 1st, 2024, something called RUBS, Ratio Utility Billing System. So something like comm service, where a third party is kind of splitting up your utilities and charging out to the tenants. That's no longer allowed. So the total rent that the tenant pays should include utilities in it. So the tenant is always going to pay one amount of rent every month, and it's just going to be consistent that way. So inside the rental agreement, it should state the total rent amount, and then if you're having them pay utilities, it should specify the type of utility. So you say this, includes water, garbage, sewer, parking, pet fees. It should sort of just state out very clearly in the lease what's all included. Now, if you already have tenants and you're using a RUB system, that can continue until you have completed your utility adjustment petition, with the city. So it's a long, it's kind of a long process just because we're have to do it with every single property in the city of Mountain View. So your RUB system will continue probably for a while until you get the final order for your petition, and then you can adjust the rents, as necessary. And then utility charges for vacant or newly rented units should not be allocated to existing rental units through any kind of RUBs or similar system. So that's for existing tenants as well. But if you have your tenants paying directly to a utility service provider like PG&E, for example, those are exempt. So we don't need to do this whole process for that type of utility where the tenant pays directly to the provider. All right, so the petition, it's a big deal and it's very important for all of our landlords to make sure that they complete it, or at least let us know if it doesn't apply to you, because it has some pretty big consequences for landlords. So I just want to make sure if you don't know about it, that we kind of connect with you. But it's a one-time process that's meant to incorporate the cost of utilities into the current rent. So it's sort of like a catch-up period. And then there will be a total amount of rent that the tenant pays. So it's just combining those two things into a total rent. And so the landlord needs to complete and submit the petition in order to qualify for the adjustment. Otherwise, if the landlord doesn't submit by the deadline, they just lose the ability to charge RUBs altogether, and then the tenant is going to only be paying their physical rent. So that chance to kind of catch up and combine them will be gone. And so we don't want any landlords to be in that situation. All right, continuing on with rent increases. Now that we kind of talked about what is rent, now we'll look at rent increases. So I kind of touched on this a little bit before, but we have the base rent and the idea of the rollback, because again, one of our number one in our substantial compliance list was the rollback needed to be done. So if you had a tenant that's living on your property that started on or before October 19th, 2015, then you needed to roll back the rent to what they were paying on that day. And that would be the rollback. If you did that, then good. If your tenants moved in after that date, then you don't have to worry about it. So if they moved in after that, their base rent is just the initial rent when they started their tenancy. So number 2 on our list of compliance is making sure that lawful rent increases have been given. And what that means is that the tenant is allowed to have a rent increase at least every 12 months. So you have to wait 12 months until you give a next rent increase. In order to give a compliant rent increase, the annual rental housing fee had to have been paid. You had to have registered with the city, and then you have a habitable place to live. So you're kind of in compliance with everything we're going to be talking about now, of course. Otherwise, you're not able to increase that rent. So our current annual general adjustment, our AGA, is 2.4% for both rent stabilized apartments and rent stabilized mobile homes. And that is applicable between September 1st of last year and August 31st of this year. And then coming up for 2025, so this sort of period starts September 1st, 2025 and goes through August 31st, 2026. For the CSFRA, it will be 2.7%. And for mobile homes, it's 1.6 because they just adopted and updated their ordinance to actually lower the rent increases to 60% of the CPI instead of 100% of the CPI. So that's why moving forward, they're going to be 2 different numbers, whereas before they were the same percentage. So if you're in a mobile home, this is new. And also, if I'm going on and you have a question, just feel free to raise your hand and I'll take a pause. and we can just address whatever the question is right when we're in the section. Or you can wait till the end, either way. Alrighty, so we also have allowed banked rent increases with the CSFRA and the MHRSO. So banked rent increases are allowed. So it's basically when a landlord decides not to charge a allowed rent increase percent in 1 year, and instead they hold on to it, and then they add it on with their next year's rent increase. So they kind of keep it in the bank and then they cash it out. So you're allowed to do that, but it's limited up to 10% in any given year. And we did have a couple times where people had more than 10% banked because some landlords withheld rent increases during COVID. And so people had maybe 12% that they could have given, but they would have to save that 2% for the next year because you can only give up to 10% in any year. So that's kind of just how you got to keep track of the math, I guess. All right, so again, proper noticing with rent increases, have to give at least 30 days and one every 12 months. And with the banked rent increase, there is a form that the city has made, which has all of the required language that you need to give your tenants. So it's easy, and we have it in different languages if you need it that way. But you should give the banked rent increase on that form, and then give a copy to the city within 7 days. And you can upload that in your online rent registry profile. And if you don't have one, I can help set you up with one, because that is also another requirement. And just something to keep in mind when rents can be raised up to market rate. So upon the voluntary vacancy and when a new tenancy starts, so basically vacancy decontrol, so tenant moves out, a new tenant comes in, you can set them right at market. You don't have to continue on with the last tenant's rent. And if you have sort of a situation where there might be like roommates, once all the tenants on the original lease left, then you can bring it up to market. So as long as there's at least one, say there's 3 roommates and 2 of them moved out, but one original one is still there, then it's still under that original lease-based rent with allowed rent increases going that way. But once all the original tenants have left, then you can negotiate up to a market rent. Okay, so now that we've talked about rent and rent increases and how to kind of lawfully do that, we'll look at our rental housing fee and our property registration requirements, because not doing one of these 2 things is another way to be substantially out of compliance with the CSFRA. So what is the rental housing fee? It is a fee when the rental housing committee adopts a budget, and we divide that budget amongst the number of covered units in the city. So this last year, the fee you paid in January was $120, and it was due January 31st. So if you didn't get your invoice or you haven't paid your fee, let me know. So we're currently in the cycle for the next budget, and it's looking like the fee next year will be $130 for CSFRA covered units, and it will be $285 for mobile homes. So just so you can kind of look ahead, you'll notice it was a little lower down around here and the year before, but I didn't have room for that. We tried to intentionally kind of keep it low because landlords were also affected pretty heavily by COVID. So we did our best to keep the fee really, really low during kind of like the years coming out, like during COVID and the years coming out of COVID. So you'll just sort of see that pattern there. As with all data points these days, there is definitely a COVID impact area. So then a totally separate requirement is the rent registry. So landlords are required to register their property every year. And so we have an online rent registry, and in my opinion, like the hardest thing is like the first year that you do it when you input all the base information. And then after that, you can just kind of update it as things happen. And then you're really ready to go by the time it comes due in January. But there are some certain things that have to be entered into the database. So you have to have your owner contact information. If you have a manager, you have to have their contact information. And then you have per unit information. We don't ask any personal tenant information like names or phone numbers or anything like that. It's just number, like unit numbers, number of bedroom, bathroom, and then what that unit pays for rent. And just while we're talking about registration, you can also use this platform to upload any of your required notices. And you can do that online. So that would be termination notices, those bank rent increase notices we were just talking about, and any tenant buyout form agreements. You can use the registry to do that if you prefer to upload it online. It gives you kind of a nice receipt because it lives there forever and it tells you the exact time and date that you submitted it. So if any questions ever arise, you have a nice record of it there. All right, so again, information, oops, that's not supposed to be there. That was the wrong slide, sorry. But anyway, here's sort of what I was just talking about the information that's required to be on there. So any changes with contact information need to be made within 30 days. And then again, you can use it as a platform to submit those required notices. One thing, since I have your attention, that I always like to mention because I think it falls through the cracks. I think most people know by now that they have to submit any termination notice within 30 days, but you also have to submit termination notice follow-up documentation within 7 days. So if you're actually going through like a court process, or if a tenant leaves because they received a termination notice, you have to report those things back. And you can do that through the registry as well. So UD paperwork that's served on the tenant, judgments that you get from a judge, those all need to be uploaded into the system within 7 days. Bank rent increase is a 7-day deadline, and then buyout agreements is a 15-day deadline. And so now we'll look at what happens if you don't register your property and if you don't pay your fee. So again, those both are considered substantial compliance issues. So if you don't do it, your property is substantially out of compliance and you're not able to raise your rent. So again, we mail out those letters. Oh yes, this also posted onto the website. There's a section in the overview of your registration that lists if the property has paid and if the property has registered. So it is public information in that way. It doesn't go into any detail. It just is like sort of a yes or no, but it is at the mvrent.mountainview.gov website. And then on top of that, there's also late fees for non-registration and non-payment. So if you don't pay, you are hit with a 4% per unit per month fee. So that adds up. And then with registration, it's $25 per unit per month. So those can really add up pretty fast. So I know on my side, I do a lot of outreach to landlords to try to make sure they don't include any of those late fees. But always sort of expect these things to be due by the end of January. And so if for whatever reason you didn't get your invoice or you didn't register, you kind of like have it in the back of your mind that that happens every year. And so again, just kind of touching on registration and fee payment, there are certain people who may qualify for unit exemptions. So if you do qualify for that, we deduct that from your per unit cost of your rental housing fee. So it would have been $120 less this year. So unit exemption mostly is owner occupied units. Or if you're one of those funky properties that have like a couple duplexes and some single family residence on them, any duplex on your property is exempt. So you can claim that to make sure you're not paying for duplexes. And then if you're building any new construction, there's been a lot of ADU conversions or build outs. Lately, a lot of people are like converting carports and things into ADUs. So you want to make sure to report that to us as well. All right. Any questions about any of that? No? All right. Habitability. So this is our kind of final reason for major substantial noncompliance is failure to maintain habitability. And so there's kind of both state and local laws around what habitability is, and it sort of can define certain standards of living that must be met in order for people to have like a safe and healthy place to live. And then the local code just provides more clarity and more detail on those things. So if you're interested in taking a look at what those are, here's where you can find them. And again, there are certain things that are tenants' responsibilities. So I'll just mention it here. But they are expected to take reasonable care of their unit and the common areas. And they are expected to promptly notify a landlord if any kind of problem arises or if something is broken. Um, that way, the landlord has time to fix it quickly, and so the problem doesn't get worse and become more expensive and maybe affect the property in a larger way. And then, of course, the tenant is responsible for any damage caused by them or guests or pets. But as far as for property owners and compliance, they need to provide the unit in, habitable condition, which includes having working plumbing and gas and heating and electricity. The structure needs to be sound, so roofs, exterior walls can't be broken or damaged. There should be no vermin or garbage, and there needs to be working locks and windows there. Locks on the doors and on the windows. So that's what's expected. And there's sort of some recommendations that we always like to talk about. One of them is now a new law, but that's performing the walkthrough inspection at the beginning and at the end, and actually documenting taking those pictures now is a must. You can also take a video, it could be helpful, but just to have the actual state of the unit documented if anything should come up later on down the line. Another thing you can do as a landlord is require renter's insurance and have that written into your lease. And that way it protects both you, and if there is any personal damage to the property from the tenant, they can use that to help fix that. And then we also have a mediation service in Mountain View, and it's totally free for anybody who lives in Mountain View or anybody who owns property in Mountain View. And it's a really proactive way to resolve disputes between tenants and landlords. And it kind of maintains the relationship between the two of you so that it doesn't have to get adversarial, and especially nobody wants to go to court. So of course, if there's habitability issues and they have to go into the unit to fix something, you do have the right to enter that unit to do those repairs, but you just have to do it lawfully. So 24-hour written notice to the tenant that states the time, the date, and the purpose of the entry. Obviously not applicable in cases of an emergency. And it needs to be done during normal business hours. The tenant does not need to be present, but they can if they want to. So if they deny you lawful entry, that is one of our just cause eviction reasons, but you would first have to give a notice to cease and then, try to enter again. And if they did it again, then you can give them the termination notice. That's kind of how that would work. So now that we've covered in kind of some more detail our major categories for what substantial noncompliance is, what happens again if you're not in compliance? So again, the major thing is that you're not allowed to legally increase rent. However, if you did increase rent at a time when you were non-compliant, you would either want to proactively fix that and do the appropriate rent refund for the tenant. So any overpayment that they paid, you would want to give that back and sort of fix it. And then in the case that no rent refund was given, the tenant can file a petition with the city to have a decrease in their rent because of that overpayment due to the non-compliance of the property. So I won't go over this totally again because it's just sort of a reminder from the same slide that we talked about earlier, but we send out the letter to the landlord. If it's still not resolved, a letter goes to the tenants. And then also you can accrue those fees for failing to pay your registration, or sorry, failing to pay your annual fee and failing to register your property. So this is just like a snapshot of what the letter actually looks like. So we have all the main categories. So registration, unpaid fees, unlawful rent increases, rollback not implemented, habitability issues. So whichever one or whichever ones apply to your property, they will be marked on this letter, and underneath there is a little section here with a corrective action, and it explains to you how you can fix the issue. And again, just so you have a snapshot of it, if the issue is not fixed, this second letter goes out to you and a copy goes out to the tenant with this cover sheet on it that basically says you're a tenant living in a property that may be substantially out of compliance with the CSFRA. Landlords are not able to increase rent. If you had a rent increase, contact the office. So it's a short little cover letter. And then finally, again, if one of those non-compliance things happened, the tenant did get a rent increase, they can file a petition for unlawful collection of rent. And then they could also file a petition if it's a habitability issue, they can file a petition for that as well. So on top of the letters and some of the fines you may get, you may also get a tenant petition for a refund of some of that rent in case you're out of compliance. So that's sort of the end of the presentation. I guess I'll end sort of on a positive note though. There are ways to correct your non-compliant issues, and our office is definitely more than happy to help you with that or come up with a game plan with you on that. So here on this screen is our information. You'll see at the bottom right is our phone number and our email address. We also have office hours for landlords. They're actually happening now. This is sort of part of that whole program, but they are every Thursday from 1 to 3 p.m. So rent rollback calculations, utility adjustment petition calculations, habitability concerns, all of those things was what we're here to kind of help you with and talk through with you. So we really encourage our landlords to come out and talk with us to kind of make sure that you're on track, because there are, a lot of laws to kind of keep track of. So we try to help with that as much as we can. So I do just kind of want to end on that positive note, and I'll put this screen back up. But there are also other resources. Here's the information for our mediation program. You can find some lawyer referrals at these sites, and this presentation will be emailed to you, so you'll have these. And then again, here's our contact information. And again, yes, every Thursday from 1 to 3. We also have virtual office hours on Tuesdays from 10 to noon, and we're available there as well. You can always come to our office between 9 to 5, Monday through Friday, to get help. So we're always here and available. Alrighty. Any questions, thoughts, or ideas? I think you can raise your hand, or if you want to type it in the chat. If not, thank you for coming. This, again, like I said, this will be emailed to you along with a link to the recording, so you can just have it in case any questions come up in the future. Alrighty, have a great day.